So as Greg mentioned, my name is Simran Panach, and I'm an associate with the Corporate Finance Group with Gowling WLG. And I'm here today to present on letters of intent, or LOIs for short. And we recognize that there's going to be different levels of expertise on this call. So for some of you, you will have dealt with very many LOIs. And for some of you, you might not have seen very many LOIs. But our goal with today's presentation is to provide more of a higher level overview of LOIs. And we hope that after today's presentation, you will all have a better understanding of the importance of an LOI in a transaction, the benefits an LOI can bring, and how an LOI can be used as a tool in your business. So this is the roadmap for today's presentation. I'd like us to begin by discussing why a transaction should have an LOI. Then I'd like to move into how an LOI can be used in a variety of different scenarios that may come up in your business. And then I'd like to spend some time discussing key terms that parties may want to consider including in their LOI, and why parties should consider having these discussions and agreeing to these terms prior to drafting a definitive agreement. And then I'd like to give some additional considerations for parties to think about during COVID-19 in relation to LOIs. So to help illustrate why parties should have a letter of intent in their transaction, I'd like to give an example of what happens when parties don't. So last year, I assisted on a transaction where our client was purchasing the assets of a company that he'd been employed with for several years. So our client and the seller had a very long and personal relationship. And so when they entered the transaction, the parties didn't think it was necessary to prepare an LOI. They felt that it was relatively simple, and they didn't think that there was going to be very many terms that required heavy negotiation. However, when we began drafting the definitive agreement and began having discussions with our client on the business that he was purchasing, what resulted was that there was actually a variety of terms and conditions that our client wanted included in the definitive agreement that he had not yet discussed with the seller. This led to complications during drafting of the definitive agreement because now time had to be spent negotiating these terms. So parties should consider earlier on in a deal agreeing to the terms of the definitive agreement and putting that in writing in the form of an LOI. Now, it's easier for parties to agree to these terms earlier on in a transaction because generally, parties are more friendly and willing to cooperate. Both parties are very eager to close the deal. And because there is this eagerness, it's easier to settle some of the terms. So while sometimes parties may think that an LOI is not a crucial step of a transaction, or may even worry that it might lead to unnecessary delay in the beginning of a deal, it's actually the reverse that's true. If parties spend time preparing an LOI, they prevent delay later on because time does not have to be spent negotiating these terms when you're drafting the definitive agreement. And it also prevents conflict from developing between the parties because all the parties will be on the same page as to what the transaction will look like, and there won't be any sort of surprises that might come up. But it's important for parties to recognize that it's not just enough to have an LOI. Parties should consider spending time earlier on in a deal thinking through the transaction and the business to determine what terms and conditions should eventually form the definitive agreement. And so really an LOI can be tailored for the business and the transaction. And it's at this stage that it's a good point to get legal counsel involved. So most times, parties may think that a lawyer should really only be involved during the definitive agreement stage, but that's a misconception. Lawyers can work with you at that LOI stage to make sure that all the relevant terms and conditions that need to be included in the definitive agreement have been considered, and to ensure that you and your business are protected. So if parties have a good LOI, this will ensure that there is clarity between the parties on the terms of the transaction. It will lead to simplicity when closing the deal, and it will maintain agreement between the parties and avoid conflict. So really, an LOI should be considered the building blocks of the transaction. So the more building blocks that parties have, i.e. the more terms that have been agreed upon, the easier it will be to close the deal. So I'm sure that most of you have seen LOIs used in M&A transactions, such as a share and asset deal. And this is one area that LOIs are most commonly used. But there's actually a variety of different scenarios where LOIs may be beneficial for parties to consider using. For example, parties can consider using an LOI in a capital raising transaction. And in a capital raising transaction, that's where LOIs would be used in the form of a term sheet. And this term sheet would contain the specific terms of the offering, such as the security being offered, the subscription price of the security, the size of the offering, and the closing date. And by having a term sheet in place, what this ensures is that all parties, such as investors, the corporation, and any brokers, all have details on the transaction. You can also use an LOI if you are negotiating a services agreement, a co-development agreement, a distribution agreement, and really it can be used in any agreement where you will be negotiating the terms of entering into business with another party. So while an LOI can be used in a variety of different scenarios, the focus of today's presentation will be more on M&A transactions because this is the most commonly used scenario. This is a scenario where LOIs are most commonly used. So one term that parties may want to consider including in their LOI is the purchase price. And so parties would want to consider including the amount. So how much will the purchaser be paying to the seller for either the shares or the assets that they're purchasing? Parties also want to consider thinking about the mechanics. So how will the purchase price be satisfied? And it's on this piece that we see that the seller and the purchaser are diametrically opposed in terms of interest. For the seller will generally want to have the purchase price paid in the full amount in one payment, and they'll usually want it paid in cash. But on the other hand, for the purchaser, they may want to structure the payment of the purchase price based on the needs of their business. And it may not be beneficial for their business to pay the purchase price out at once. If this is the case, there are other forms of payment, such as a promissory note, a vendor take-back note, and the issuance of shares that the purchaser may want to consider using to satisfy the purchase price. The purchaser can even ask to have an adjustment provision built into the definitive agreement to adjust for the profitability of the business. So there's really a variety of different approaches that can be taken with respect to how the purchase price will be paid out. And we can work with you to ensure that the mechanics meet your business needs. There are also a variety of different tax considerations that parties need to think about in relation to the purchase price. And there's different tax considerations if you are selling shares versus assets. So when structuring the transaction, so determining if it's going to be a share purchase or an asset purchase, it's important for the structure of the transaction to be reviewed by the seller and their tax advisors to determine if the vendor can use any exemptions, tax exemptions that are available, such as a capital gains exemption. And it's important for parties to determine the selling strategy before the LOI is signed so that the purchase price can be allotted to the class of assets, the goodwill, and the eligible capital property prior to that LOI being signed. So on the tax piece, we're also going to find that the seller and the purchaser usually want different things. So for the seller, it's usually more advantageous to structure the transaction as a share transaction, a share purchase, because what this allows for the seller to maximize their use of the capital gains exemption, and in some cases multiply their use if there's, for example, family trusts involved. But for the purchaser, it's more advantageous to have it as an asset transaction, because this allows them to limit the liabilities that they're exposed to, because the liabilities are limited just to the assets that they're purchasing. And it also allows them to increase the basis of the asset and class of assets on the balance sheet. And they're likely going to want to depreciate and amortize the class of assets to the maximum amount available. So there's really many considerations to think about in relation to the purchase price. And because there's a opposition in terms of interests of the seller and the purchaser, it'd be advantageous for the parties to get this settled earlier on in a transaction when it's easier to negotiate and settle on these terms. Parties may also want to consider the reps and warranties that will be included in their transaction. And the reps and warranties that parties may want to include, will want to include in the transaction should be business and transaction specific. And so really there's not just one set of reps and warranties that can be used from one transaction to the other. They really can be tailored for the specific transaction of the business. One such example of a rep and warranty that could be used that would be a little bit more transaction specific is a transitional services period provision. And a transitional services period provision is advantageous where you have a seller buying a seller selling their business to a purchaser who may not have knowledge of the business that they're buying. And what it allows is it allows for the purchaser to retain the services of the seller for a certain period of time after closing to allow for a smoother transition of the business. Where I've seen this used is I assisted on a transaction recently where our client was selling his business that he had had for about 30 plus years. And really, he was the only individual that had the know-how on the business. And he was selling it to a private equity firm that had never been engaged in this type of industry. And so to ensure that the transition of the business was smooth and to increase the chances of the profitability of the business after closing, we built into the definitive agreement that the purchaser was going to retain the services of our client as an employee for about a year after the deal closed. Parties also want to consider how employees will be dealt with in the definitive agreement. So what reps and warranties will be included in relation to the employees of a company. And there's different considerations to think about depending on the type of transaction in relation to employees. If the transaction is a share transaction, because there's no employment contracts terminated, what parties should be thinking about, especially the purchaser, is if there are written contracts in place. And so if the seller only has verbal contracts in place, the purchaser may want to consider including provisions in the definitive agreement that would require the employees to sign written employment contracts at closing. In an asset transaction where you have employment contracts being terminated, the considerations are different. And so in this case, the parties need to be thinking about which employees will be rehired, what the terms of the new employment agreements will look like, and for any employment agreements that will be terminated, how will severance obligations be satisfied? For the most part, usually it is the seller's responsibility in transactions to pay out severance, but there are cases where sometimes the purchaser can agree to assist with either some or all of the severance obligations. If the transaction, if the business that's being bought has any sort of intellectual property, then it would be advantageous for the purchaser to include specific reps and warranties around IP. So for example, the purchaser may want to consider including a rep whereby the seller would be repping that all IP rights have been assigned from parties such as employers, developers, and contractors to the seller prior to closing. If the business that's being sold has anything to do with the environment, so for example, if it's an oil and gas company, the purchaser may want to consider having the seller rep and warrant that, for example, all environmental regulations have been complied with. So really, the reps and warranties that parties can include in the definitive agreement can be tailored to the specific transaction, and it's advantageous for parties to think the business through earlier on in a transaction before the definitive agreement even before the definitive agreement drafting is started. Another term that parties...
Can I just interrupt there and
of course.
let the attendees know that yesterday, Gowling's M&A team out of Toronto did a webinar where they talked about representations and warranties, and the MAC clause, material adverse change due to COVID-19, and how the MAC clause, depending upon how it's drafted, can either hinder or help your deal, especially in the light of going forward now, COVID-19 issues, dealing with force majeure and the strict definition of force majeure in the definitive agreement. So it's beyond the scope of this discussion, but I just wanted to bring it forward that those webinars are on our Gowling main website under a certain tab called COVID-19 webinars, and people can download those for free afterwards. Okay, thank you.
Right. Thanks, Greg. So another term that parties may want to consider including in their LOI to be included in their definitive agreement is covenants. And so covenants really are advantageous for the purchaser because they provide a form of protection for the purchaser by restricting the seller's ability to do certain things after the deal closes. So some examples of these covenants are non-competition covenants, which would ensure that the seller would not be able to engage in any way in a business that competes with the business that the purchaser is buying. Non-disclosure covenants, whereby the seller would covenant not to disclose any confidential information for a certain period of time after the deal closes. And a non-solicitation covenant, which would prevent the seller from soliciting any employees or customers of the purchaser after the deal closes. Now, I'm sure that most of you have seen these covenants used in M&A transactions because they are quite common. But even though they're common, they can be quite contentious because what they do is they limit the seller's ability to do business for a certain period of time and within a certain area. And so because they can be sometimes contentious, it's advantageous for parties to, if they want to include covenants in their definitive agreement, to discuss and negotiate them earlier on in a transaction when parties are more willing to cooperate.
And Simon, just to add some tax aspects to covenants not to compete, Income Tax Act Section 56.4 sub 7 has a number of ins and outs and safe harbors for covenants not to compete, and they have to be executed properly. Their terms and conditions have to be well thought out because there could be adverse tax consequences to the seller, vendor, covenantor in those instances. So that's again beyond the scope of this presentation, but just wanted to highlight that.
And I'll just add to that, Greg, that it's important in these situations to also include legal counsel because a lot of the terms that may be desired between the parties, may not be enforceable in court. So the changing landscape with respect to covenants such as non-competition provisions, happens all the time with employment law. So it's important to get a legal counsel involved in the right time there to provide some guidance with how that covenant ultimately is drafted and takes shape in the LOI, so that there's common understanding between the parties right from the get-go.
Correct.
All right. So as you can see, an LOI really can be used as a roadmap for your transaction. But you can also use an LOI to include certain provisions that would be binding upon the parties to dictate the relationship of the parties in that time period from when the LOI is signed to the signing of the definitive agreement. And so one such term that parties may consider including in their LOI that would be binding is an exclusivity clause. And what an exclusivity clause would ensure is that it would provide the purchaser with peace of mind in knowing that when they are spending their resources on negotiating and doing their due diligence, and that when they get to that point where they're able to sign the definitive agreement, that the seller hasn't found a better offer and is then going to walk away from the deal. And so you can build in an exclusivity clause to state that for a certain period of time, the seller will be prevented from finding any other offers. And so this allows the purchaser to have a peace of mind while they are going through these negotiations and doing their due diligence.
Simon, I'm just going to cut you off here very quickly. We have a question here from Eugene. So, Laureen, if you don't mind opening the mic here to Eugene.
Hi, Eugene. I think your mic is on. Eugene?
Sorry. Oh,
We can hear you.
yeah, I have no questions. Sorry.
Oh, okay.
Okay,
I'll try and mute.
thank you. Sorry, Simon.
That's great. Perfect. So there's also certain outs that can be included in the LOI that basically provide an out for the purchaser to walk away from the transaction. So the purchaser may want to consider including a due diligence provision. And what the provision would essentially state is that if there's anything that comes up during the due diligence, the purchaser would be able to walk away from the transaction. But the due diligence provision could also state that the seller has to provide access to the purchaser to its records to perform due diligence. You can also include a financing condition. And what this condition would allow is it would allow for the purchaser to walk away from the transaction if they're not able to find financing. And so the closing of the deal would then become conditional upon the purchaser obtaining financing. There's also a series of terms that the parties may consider including that would be advantageous for both the purchaser and the seller. So for example, parties may consider including indemnities, and these indemnities would essentially be provided for any sort of reps and warranties that might be in the LOI. It could include confidentiality provisions, which would ensure that any confidential information that might be exchanged during negotiations is kept confidential without and cannot be disclosed without the consent of the other party. And a no public disclosure provision, which would prevent any party from making any public announcement of the deal without the consent of the other party.
Simon, may I interrupt there and just add a comment that on this slide and the previous slide, we could also introduce the concept of refundable deposits and or non-refundable deposits in the LOI with respect to due diligence and financing and drop dead dates, so that the seller has some comfort on disclosing and opening up its books and records to the potential acquisitor or buyer, that there is some good faith deposit placed into trust with either buyer's counsel or seller's counsel, and some distinct timeframes when they have to, kick the tires and then make a decision or walk. And whether or not that deposit is fully refundable or partially refundable, that's a negotiation amongst the parties at the LOI stage, and it can, be discussed at that point. And naturally, counsel on both sides should be involved in that discussion, because an escrow in one of the two solicitors' accounts may be appropriate. So I'll hand it back to you.
Right. So in connection with the additional terms that we've discussed that can be binding on parties in an LOI, so such as the exclusivity, due diligence, the financing conditions, here's some additional considerations that parties may want to think about in connection with some of these terms during COVID-19 for any LOIs that they may currently have or any LOIs that they may be considering entering into. So for exclusivity, what parties may find is that their initial exclusivity period for due diligence and negotiation of a definitive acquisition agreement may be too short. And what's likely to happen during COVID-19 is that purchasers are likely going to be requesting very long exclusivity periods, given the uncertainty as to when social distancing measures will end and non-essential businesses will be allowed to reopen. But sellers are likely going to be resistant to being tied up for a period of many months rather than a few weeks, which is more common in normal circumstances. With respect to due diligence, the restrictions that are now in place for non-essential business activities, travel, and group gatherings are going to have a significant impact on transactions that require physical inspections or inventory counts of facilities and assets. And so even conducting these inventory counts or even environmental assessments may be impossible to carry out given the restrictions that are now in place. And this is likely going to have significant impacts and delay on the timing and execution of definitive agreements. For where you have a transaction that hinges on the purchaser obtaining financing, there's a lot of funding uncertainties that are currently happening during COVID-19 that may put a deal at risk. And at this stage in the crisis, many lenders and equity investors are more focused on their existing portfolio investments as priority. And until they have a better understanding of the impacts of the pandemic on current investments, it's likely the new investments will be delayed. The funding capacity of these investors will also need to be considered in light of the pandemic. As well, with the pandemic, there's also, of course, increased risk due to supply chain disruptions and decreases in workflow due to remote work policies. And to allocate this risk, this can take many forms, such as having additional reps and warranties in place in the agreement, covenants, further escrow or holdback of proceeds, or even having a reduction in the purchase price. And so because of the uncertainty around COVID-19, we recommend if you're going to be entering into M&A transactions, or even transactions you might currently have LOIs signed for, that you talk to your legal, tax, and business advisors on what you can do to mitigate the risk during COVID-19. So an LOI really is a simple but powerful tool. You can tailor an LOI for your transaction, and you can use an LOI to dictate the relationship of the parties between the time period from when the LOI is signed to when the definitive agreement is signed. It's also important to remember that an LOI is an agreement to agree. So while most provisions of the LOI are not enforceable, an LOI brings parties together to negotiate and can form the roadmap to close a transaction. Now, you don't need to necessarily have every single term of the definitive agreement agreed to prior to drafting, but by having the main terms figured out, it'll make it that much easier to close the transaction. And because there are so many considerations that parties need to think about when they do enter into a transaction, it's a good idea to involve legal counsel. So legal counsel is here to help. We can help out in a variety of different ways. We can assist with drafting an LOI, reviewing an LOI that has already been drafted to make sure that nothing's been missed, and we can even negotiate on your behalf in the earlier part of the transaction. And so really, we can work with you to ensure that you and your business are protected during and after a transaction. So as mentioned before, we've left some time for questions, and we really appreciate your time today, and we hope that this has been helpful and informative. Lauren, I think we can open it up to questions.